Hello, and welcome to this edition of Fulton Justice. I'm your host, Yolanda Lewis, District Court Administrator for the Atlanta Judicial Circuit. Thank you for joining us. The United States Supreme Court recently made a landmark decision affirming marriage equality for lesbian, gay, bisexual, and transgender Americans. In its recent decision, the Supreme Court determined that it is unconstitutional for a state to ban same-sex couples from exercising the fundamental right to marry. In 2013, the Supreme Court ruled that Section 3 of the Defense of Marriage Act, DOMA, which previously limited any marriage benefits under federal law to opposite-sex spouses, was unconstitutional. Our guest today will talk about the recent decision of the Supreme Court and the genesis of that decision, which started back in 2013. Mr. Hannibal Heredia, a local family law attorney, will give us his take on the Supreme Court decision and its outcomes. Stay tuned. Welcome back to Fulton Justice. Joining us now is our special guest. We welcome Mr. Hannibal Heredia. Thank you so much for being here today.
Thanks for having me.
So we're going to get into a real big issue with the Supreme Court ruling on marriage equality, but I want to talk a little bit about who you are before we get into that. Tell me a little bit about your background.
My background? Well, I grew up in Alabama and I went to law school in Los Angeles.
Right.
And I've been practicing family law pretty much since I got out of law school, and moved here to Atlanta, Georgia.
And so your firm now?
Hedgepeth, Heredia, and Reeder. We're in an exclusively family law practice. We do anything ranging from divorce and matters that come after divorce or before divorces. We also do adoption work, surrogacy work, and prenuptials.
Okay. Tell us a little bit, because you practice a lot in the Fulton County Superior Court, and specifically with our family division, and you've been really involved in our family division task force. Talk a little bit about the work that you do every day, but then also the role you've played on that task force.
Okay. Well, on an everyday basis, I mean, we're handling most of our bread and butter divorces. And so we're in Superior Court a lot, which is where divorces land up. And Fulton County is the only county in the state of Georgia that has its own dedicated family law division. And recently, I was honored to be selected to serve on the task force to basically go in and look at what the family division had been doing since it started approximately 15, 16 years ago, and where we could go now. And so we spent a year with several lawyers and other volunteers from the government, the county, and worked together to assemble a report and recommendations because funding comes from other places.
Right.
And we need to go to those funders and say, we have some ideas how we can improve the system. And one thing I worked on, I was really proud of, is I worked on the component that had a lot to do with access for people either who speak different languages or of lesser means, and how we provide more access and more services to those folks.
And the task force has its recommendations that are now going public. And talk a little bit about some of those recommendations. I know one of the big recommendations is has to do with custody and parents exchanging custody, the environment in which you do that, and also the need for additional resources, judges in the division. So talk a little bit about how you believe some of those recommendations are the best recommendations for the court.
Well, if you think about any typical Superior Court, the judge handles criminal, they handle family, they handle civil. That's kind of what you think about as a judge. Our family division handles nothing but family law. And if you go across the state, the majority of the cases of any typical Superior Court judge is family law. And it is maybe an unfortunate fact, but true fact, that there's just that many family law cases that go through a court system. So if you look at Fulton County, we had 3 Superior Court judges handling that entire load for quite a while. And one of our recommendations is to add a judge, and which I think will help a lot. And you're now spreading more cases among more judges, logically. But with those recommendations, we've also recommended that there be an increase in staff, that there be a kind of a permanent structure so that as judges rotate in and rotate out of the system, there'll be a structure left behind that's not something they have to learn every single time. You have clerks that actually do this on their permanent basis.
Right.
I think that's going to tremendously help not only the attorneys who work there, but the judges, their staff, and then most importantly for the litigants and the parties who are involved. You get greater access to the judges when they're not when they have less cases. Obviously, and they can hear the cases. We always want people to try to settle the cases, but the reality is you do have to have some judges.
Right.
As far as the other topic you brought up, which is the custodial part of it, again, I think that was kind of part of, we broke into subcommittees, and I had been a legal services attorney in my beginning of my career, and so I think I used to joke all the do-gooders ended up on the access committee.
Right.
And so we had some of us legal services types in there, and one of the law clerks, and we really looked at how the other family divisions in other states do things. And one of the topics we were looking at are when we have supervised visitation, what kind of resources is available, how can we integrate this into our system, and also just a general idea about increasing our center that we have now, where people without lawyers can come in and use it. We have a pretty good system now.
Absolutely.
But definitely thought there could be some improvements made, and also the website. That's so where everybody goes now.
Yeah.
And I think that Fulton County has done a pretty good job with their website. But when you looked at the other sites and how either there was so much information on it, and ways to integrate the public to it very easily, it's very inspirational. These other states that have, they had a head start on us.
Yeah. Yeah.
But it was very inspirational. I think that is where a lot of people, now go for their information.
Right.
I also used to work in the rural counties, and I left the rural counties about 9 years ago. And I mean, most of my clients didn't use a lot of email,
Right.
didn't do the websites,
Absolutely.
but that's not the case anymore. I mean,
Right.
everybody's well versed in it. And so we looked at the websites, but again, it's just a matter of recognizing that different people of different types come through the system, and you want to make it accessible to all. And I think we really have done a good job of increasing some of that accessibility.
Yeah, I think the report is going to completely revamp and change how we do business, which is great. And I think, every now and then you need to take a look at what you're doing and see how you can do it better. So thank you for your work on the task force.
Thank you.
So let's talk a little bit about this Supreme Court ruling.
Okay.
And I know we'll talk more extensively, but I think the day the ruling came down, people were celebrating that this was something that was going to give a sense of equity to other people across the country. But there were still questions about what it meant. So tell us a little bit about what this ruling really means.
At its bare essence, because you can really go into lots of layers. It's an onion. You can peel it away for
Right.
quite a while. But
Right.
at its bare essence, it said you can't deny someone a license to marry. I mean, that is if you just strip it all down, that's basically what the ruling is saying. And so, obviously, the ripples come from that, which is the logical takeaway is, gay and lesbians have a right to marry now, because the states should not be denying access to the license. So that's its bare essence. I mean, then again, like I said, if you start looking, there's going to be ripple effects everywhere you turn from it. And obviously, as you said, we're celebrating, and the interpretation is huge of what this means for gay and lesbians, and especially for our country. But that's what that decision, among all those many, many, many pages,
Yeah.
actually, that's what it comes down to.
So one of the things that I've heard people talk about, I want to talk about some of the benefits to a certain community will enjoy as a result of
Right.
this. Also, some of the hurdles that still exist. But a lot of people liken this to the landmark decisions that happened with the Civil Rights
Sure.
Act,
Sure.
women's right to vote. Talk about how significant it is in relation to some of the other decisions that the Supreme Court has made.
Sure. I mean, honestly, for decades now, I've always said that the modern civil rights movement was with the gay and lesbian community. Not that everything's perfect
Right.
between the races, but this was the new movement. And I actually wrote an article about it when I was a really young person. And so, I've had a sideline view of it for a while, and it is because it's, they're based on similar doctrines of equal protection under our Constitution. You had a group that was disenfranchised in many areas, similarly in our history between races. And so I do think it's a landmark decision. There's no doubt about it.
Right.
We obviously got the pregame, the foreshadowing when they struck down the DOMA, the federal act that was trying to keep the marriages. And so everyone figured that this was coming down the pipeline. I think all lawyers in many fields, because I think that's where we're about to head to, have to look at the impact it has across the board.
Yeah. When we come back, I want to talk about how this ruling now has an impact on employers, how employers should be responding. I also want to talk about some of the recent news articles that suggest that even though the Supreme Court ruling has been made, that there are still people within the system that may not be ready to adjust to that ruling.
Sure.
So we'll talk about that when we come back. Stay with us. We'll continue our discussion. We'll be back shortly. Welcome back to Fulton Justice. We're continuing our discussion about marriage equality and the Supreme Court's ruling recently that changed everything for a group of people. So we're here with Hannibal Heredia from a law firm here in Atlanta, and we're going to talk about a little bit more about marriage equality. One of the things I wanted to ask you before we went to break was about the employment situation with this ruling. Most employers are now going to have to make some accommodations when it comes to health insurance and benefits. So talk a little bit about how this ruling applies to employers.
Well, I think when you back it up for a step, prior to the decision, a gay couple, if the spouse worked, could not add their spouse to their health insurance.
Right.
I don't know that a lot of people thought about it. If you were a gay couple, you couldn't take advantage of any exemptions as a married couple. You couldn't you couldn't do the exemption of the federal. There was a way to get around it, but there was a lot of issues a lot of benefits that people don't realize, that you couldn't use. You don't get any benefits for on your car insurance, for example, if you come in as a married couple. So. As an employer, and we have a firm and we employ folks. I mean, those people are going to come on, and it's going to be based on each employer. Some employers pay for spouses,
Right.
some don't.
Right.
But if you did, pay for spouses,
Right.
and you hire a gay or lesbian individual, and they want to add their spouse, they're going to have every right to add their spouse because their marriages will now be recognized in the state of Georgia. So that's, to answer your question directly, that's what's going to happen. I mean, obviously each insurance companies, because they're larger, are probably going to honor them anyway. But
Right.
we just didn't, you could not check a box in Georgia that you were married.
So let's talk about that, because I think that's a very interesting concept. When there was some contemplation of this ruling coming down, you saw courts and other institutions related to us trying to this mass rush to change forms to make them neutral. I mean, no one thinks about the intricate things that have to change in order to accommodate a ruling like this. So what type of impact do you think? And I went to the first marriage ceremony here in Fulton County,
cool.
and trying to make sure that everything was politically correct. I mean, there's a lot to consider when you have a ruling like
Sure.
this. It's a lot. So what do you think, how significant is it that our courts, even before this ruling came down, started preparing for this in light of the most recent news story that I've read on CNN to say that now there is at least one clerk in Kentucky who's saying that they don't want to issue marriage licenses after we've gone through this process of making this possible?
Well, I was reading stories both ways, prior to the decision. I can't remember which state, but there was it was Alabama. They were, having some conflict with the governors, with the Supreme Court saying you need to do this, and then the local clerk saying we're not going to do it. And even now it sounds like post we're having that issue too. But to go back again, further back, I mean, you don't think about it. I mean, those law books right there, it says in the domestic section, it's going to say husband, wife, father, mother.
Right.
And that there's statutes all over. That's not even the domestic section. So, I mean, in the grand scheme of things, I was, impressed with some courts who were, proactive. And again, if you think about it statistically, there was only 13 states that hadn't passed their own laws recognizing gay and lesbian marriages, and Georgia was one of those. So there was a lot already a momentum going into thinking about the next phase or wave. But I think that now it's just going to be like what you alluded to earlier with the civil rights cases of the 60s. Even when those decisions came down, there were people said,
still not prepared.
We're not going to be prepared, and we're not going to do it.
Right.
And so you have some of the progeny of those cases come from the other cases that went up because someone tries to argue a glitch or a loophole, and then the Supreme Court back then closed a bunch of them up. So I would assume in this, as you said, Kentucky, I believe, I would assume that's what's going to happen here in this Kentucky case is the clerk's going to say no, they're going to be represented, they're going to go in federal court, and they're going to argue some sort of angle of, why we think that it doesn't apply here. I mean, I've also listened to a lot of the commentary and the rhetoric, and, there's still a lot of push about it should be a state's decision and their public should argue that. So I'm certain those who are opposed to the ideas and those who weren't ready for it are going to take their chances and go up, just like they did in the civil rights cases, and test, even though it's out there. And and it happened with Roe v. Wade too, when they did with abortion. People have always come in, and depending on the climate of the Supreme Court, either they close the hole or they might expand the hole the other way.
And so, I was thinking as I was reading that article about the clerk actually wanting to appeal. When a decision is this broad, this broad across the whole country, how often would that appeal really get some steam and potentially change things at that state, which may have an impact on other states as well?
Well, what I expect in any of these decisions, just from history, is that they'll make their way probably back up to the U.S. Supreme Court. That's what generally has happened. So, again, if you use the civil rights cases, they all made their way up. The holes were closed. If you look at the Roe versus Wade, women's rights to choose, they went up and they went to a more conservative court, and so things were opened up a little bit to not undo, but to change the original decision. I would assume that's what's going to happen. There will just continue to be appeals, and they'll try to take it back up. That's historically been what's happened.
We talked about the right to marry, and we talked about the right to divorce. What was the process prior to this ruling, and then what is different now?
Well, that's a great question because again, I don't know that people think about it. It just it's that what's going on when you have a group that their marriages are not recognized. So if which you could, go to all these other states and get married and came back to Georgia, we didn't recognize the marriage.
That's right.
Okay? So you couldn't check the box, couldn't get your benefits.
Right.
If you were trying to adopt a kid, you weren't married, so you have to go through this arduous process of doing 2 adoptions.
Wow.
And then, if you couldn't get divorced because we don't recognize your marriage,
so we can't recognize the divorce.
We're not going to divorce you.
Right.
So how do you adjudicate the property you guys have bought together? How do you adjudicate custody? How do you adjudicate the debts? And the way you did in the past was you used this other area of the law called a partition. I won't get too technical, but there was 2 different ways of doing it. And I've used them when I had roommates, a couple that never got married together. Maybe they were together, a romantic relationship, maybe they weren't, but they owned property together.
Right.
And there was actually a methodology to divide the property up.
Okay.
So gay and lesbian couples could use that to divide their property up. But then you went in a whole twist about the children sometimes.
Right.
If the adoption hadn't happened, and I was with my partner, for example, and we just never did the second adoption, partner didn't have any rights.
Right.
Now, if they did adopt, then they would be recognized. We always did recognize once the adoptions were signed, and I've been in courts all over North Georgia, the courts would recognize that the gay or lesbian couple, if they both had adopted, were the parents. But if for some reason you were just, on our honor system,
Right.
never did it,
Right.
that second parent who never did the adoption is out of luck, and the other person would actually have full parental rights. And so there was all these glitches that
Right.
I think, again, people didn't think about, that you couldn't get relief and straighten things out because at the beginning of this level, we weren't recognizing their marriage.
Before we wrap up, let me ask you this final question really quickly. We talked about that we still have statutes within our law that hadn't quite caught up. How long do you think it'll be before things catch up? The language in our statutes change, that everyone is properly on the same page as far as the language that we use, and the concepts itself. How long does it take when something like this happens? How long does it take for the legal community to catch up?
Well, nothing like this has ever happened. But I know myself and my law partners, both Rebecca and John, have talked about what we just talked about. And I'm certain we seem to have a very good sensitivity to it in our legislature and definitely Metro Atlanta.
Right.
So I would assume some of the energy we saw at the task force will come around to try to start doing things and get it on track. But you never know.
Yeah,
You
it
never
takes a
know.
while.
You never know.
Well, thank you for being here.
Thank
It's
you.
been a pleasure having you here. And thank you for all the work that you've done on the task force,
Appreciate
which was yeoman's work, so we appreciate you.
Always an honor.
Thanks for being here. When we return, we'll have our final thoughts. Stay tuned. President John F. Kennedy once wrote, "The nature of injustice is that we may not always see it in our own times." The generations that wrote and ratified the Bill of Rights and the 14th Amendment did not presume to know the extent of freedom and all its dimensions, and so they entrusted to future generations a charter protecting the rights of all persons to enjoy liberty as we learn its meaning. There are always unanswered questions within the law. However, the most recent Supreme Court decision answers the fundamental question of whether same-sex individuals can marry and the protections afforded to those persons in those unions. Among the most fundamental changes enclosed in this ruling are in the area of family law. The Supreme Court decision will certainly not clear all hurdles for same-sex couples, but the decision establishes an important legal precedent that will pave the way to eliminating barriers for all persons under law. Special thanks to our special guest today, and thank you for joining us for this edition of Fulton Justice. We'll see you next time.